May it please the Court Justices, Mr. De Waal, Mr. Borgstrom, and Mr. Vakele and I appear for the applicants in this matter.
May it please the Court, I appear for the first and second respondents together with Mr. Manechi and Mrs. Platt.
My Lords and Lady, I appear for the third respondent together with my learned friends Gabriel, Garni, and Kumar.
As concluded, my Lord, I appear for the Society for the Protection of our Constitution, which is amicable. Thank you.
Mr. Rosenberg, you may proceed.
Thank you, Justice Mutaba. We've prepared a chronology which we'd ask leave to hand in merely to facilitate the oral argument that we are going to be submitting. It contains a number of references which we think are important, but the purpose of it is to assist the flow of the argument and to prevent unnecessary referral to the record. Included in that chronology as well, on the last page, is a reference, a page reference to each of the volumes in question. So if there's a reference to a page, the Court will, without undue inconvenience, be able to locate the volume in question. How many copies? And furthermore, we've prepared a copy of the main authorities that we are going to be referring to. We have a copy for the Court, 3 copies for the Court, which I beg leave to hand up as well. Justices, as far as the outline of the argument is concerned, it's going to be abbreviated and reformulated in one respect. Counsel for the National Prosecuting Authority has indicated to us that the National Prosecuting Authority is, in view of the provisions of Section 22(9) of the National Prosecuting Authority Act, not going to advance the proposition that the National Director of Public Prosecutions lacks the authority to institute a prosecution. And secondly, we've been advised by counsel for the National Prosecuting Authority that the authority's approach for the purposes of this case is going to be that the decision to prosecute, the 2007 decision to prosecute Mr. Zuma, was correctly to be categorized as a corporate decision. And in view of those indications, it has obvious implications for the arguments that we've put up on the heads of argument to the Court, and in particular, the alternative argument that we put up as to non-compliance with Section 179(5)(d) of the Constitution. And depending upon the shape of the argument as it unfolds, it may be that we advance no submissions in that regard. Some preliminary background remarks for contextualization are necessary. The Court will be well aware of the history of this matter, but nonetheless some brief remarks as to certain milestones in the matter which are important, and particularly so in view of the nature of the rationality challenge which is being advanced in this matter and which will be developed in due course. That rationality challenge is centrally predicated upon the contention that Mr. Moshe, the decision maker, part of the decision maker, well, in fact, the decision maker as far as the discontinuation is concerned, failed to take proper account of or failed to attach sufficient weight to the nature and circumstances of the corruption and related charges. Now, on the 19th of June 1999, Mr. Zuma became Deputy President. On the 23rd of August 2003, the then National Director, Mr. Nguku, held a press conference to announce that while a prima facie case existed against Mr. Zuma, he wouldn't be charged. However, Mr. Shabia Sheikh was to be charged, and we know that the latter's trial commenced in 2004, and that on the 2nd of June 2006, he was found guilty on charges of fraud and corruption with a sentence of 15 years. And it would appear to be common cause that that conviction had significant consequences for a potential prosecution of Mr. Zuma.
Mr. Rosenberg, we prefer to that the third respondent should be referred to as President Zuma.
As the court pleases. The reference then was just in the sense that the third respondent at that stage wasn't the president, but of course I'll follow that. In the Sheikh prosecution, the state had alleged that over a period of some 5 years, from 1994 to 1999, substantial amounts of money had been paid by Mr. Sheikh and his companies to and behalf of President Zuma, and that this was done corruptly and with the object of influencing the president to use his name and political influence. On the 14th of June 2006, following those findings, the then president of the country, President Mbeki, dismissed President Zuma based upon the findings of the KwaZulu-Natal court that the relationship between President Zuma and Mr. Sheikh was unsavory. And this was followed up a week, in fact, on the 20th of June 2005, the decision of the then National Director of the National Prosecuting Authority, Mr. Picoli, to charge President Zuma was announced. And amongst the reasons for this fresh decision was the emergence of significant and weighty evidence which had emerged during the Sheikh trial and the facts which had been there established. And after President Zuma's appearance in the Durban Magistrates Court on the 29th of June 2005, the investigation continued and was broadened with a series of search warrants being obtained. The court will be aware that the obtaining of those search warrants led to a plethora of proceedings challenging the validity of the processes. That slowed down the progress of the investigators. In addition, the state had also applied to the KwaZulu-Natal High Court for a letter of request to the Attorney General of Mauritius. These proceedings led to the slowing down of the criminal charges, the prosecution thereof, and the court will have seen that 20th of September 2006, Missy Manje refused the state's application for a postponement of the trial of Mr. Zuma, and the matter was struck off the roll. However, on the 8th of November 2007, the SCA handed down judgments in the appeals involving the search and seizure cases, in which the NPA was substantially successful. And we would submit that in the wake of that finding, the prosecution of President Zuma had, against that background, the prosecution of President Zuma, which had become effectively inevitable after the Sheikh findings of mid-2005, had now been significantly strengthened by the additional information and documentation that had been obtained in the wake of the further proceedings. Now, against that backdrop, we need to turn to the reasons for the subsequent decision to discontinue the criminal proceedings. Before I do so, I'd like to make a few submissions in relation to the question of rationality as a basis of a legality review, that being the principal attack or basis for the attack on the decisions in question. The court will have seen from the submissions the applicant's reliance on the pharmaceutical decision. We have quoted the dictum from Chaskelson P. in that matter, where he said it is a requirement of the rule of law that the exercise of public power by the executive and other functionaries should not be arbitrary. Decisions must be rationally related to the purpose for which the power was given. Otherwise, they are in effect arbitrary and inconsistent with this requirement. And that traditional test or requirement for rationality, namely that the decision in question must be rationally related to the purpose for which the power was conferred, has been confirmed in any number of cases since then. In particular, we've referred to the decision of the Constitutional Court in the DA versus the President of 2013, 1248. That decision can conveniently be referred to as the Similani decision to identify it. The Constitutional Court has emphasized that there may be an overlap in the concepts of rationality and reasonableness. But at least on a conceptual level, one should continue to distinguish them. Of course, reasonableness as a concept in administrative law arises particularly in relation to Section 6.2h of PAJA, which postulates a relatively simple reasonableness test. Namely, the administrative action has got to be one, or it will be reviewable if it's one that a reasonable decision maker could not have reached. Formulation that we've encountered in Beto Star, decision referred to in our heads of argument. As indicated, rationality review is principally concerned with the relationship between means and ends. The relationship, the connection, the link, as it's variously referred to, between the means employed to achieve a particular purpose on the one hand, and the purpose itself. And of course, the aim of the evaluation is not to consider the possibility of better means to achieve the purpose. It's to consider a rational relationship between the means and the purpose for which the power is concerned. And we're going to be returning to and emphasizing that the rationality requirement has got to be properly adhered to. There is content to the rationality requirement. It's frequently asserted by decision makers faced with a rationality review that the level of scrutiny in the context of the rationality test is so limited as to really, in fact, amount to little more than a formality. We assert to the contrary that in the light of the authorities that we referred to and this emphasis on a rational relationship, the means and ends, and the connection that must be established, that test as formulated must be carefully and properly applied to the exercise of any public power. The court will be aware that the Constitutional Court has held on at least 3 occasions, we've referred to the authorities in our heads, that the principle of legality requires, of course, that in addition, the process by which the decision is reached must be rational and related to that notion of procedural irrationality, the failure to consider relevant facts may render a decision irrational. That much was emphasized by the Constitutional Court in Similani, where it emphasized that if in the circumstances of the case there's a failure to take into account relevant material, that failure would constitute part of the means to achieve the purpose for which the power was concerned. And if that failure has an impact on the rationality of the entire process, then the final decision may be rendered irrational. And the final remark we would make in the context of irrationality is that, of course, the power mustn't be misconstrued. SAFU, paragraphs 27 makes, Similani, paragraph 27, and SAFU in paragraph 148 make that point. And against that background, perhaps then the appropriate starting point is the purpose of the power. The power that was exercised in this, the National Prosecuting Act, amongst others, to discontinue a prosecution. Section 21 of the National Prosecuting Act confers the power on the prosecuting authority to both institute and conduct criminal proceedings and to discontinue criminal proceedings. And of course, linked to that power is the power that we've referred to in terms of Section 179(5) of the Constitution, repeated in Section 22(2)(c) of the NPA, to review either a decision to prosecute or a decision not to prosecute. The NPA's prosecution policy has been referred to in the papers. The policy emphasizes, not surprisingly, the fundamental point that crime can't be allowed to undermine the constitutional democracy in South Africa, and hence the efforts of the prosecuting authority are directly addressed to reducing pervasive criminal activities. And that's taken from the prosecuting policy of the NPA. And it emphasizes that effective and swift prosecution is essential to the maintenance of law and order within a human rights culture. Offenders must know that they will be arrested, charged and detained where necessary, prosecuted, convicted and sentenced. So much for fundamental propositions with which nobody would have any argument as articulated in that prosecution policy. The final remark in that context is that effective and impartial prosecution of crimes is fundamental to a myriad of constitutional rights. In this matter, the court will be aware that the charges were charges that bore on allegations of corruption. The court will be aware that in the decision of Glenister, the 2011 decision of Glenister referred to in our heads, the citation is 2011-347, the then Chief Justice emphasized that corruption was a scourge that had to be rooted out of society. I'm not going to read the extracts from Glenister, and particularly dicta from Moseneke, Deputy Chief Justice, and Cameron, other than to just emphasize and recite one short paragraph, because it's in particular, and we'll be coming back to this, it's of particular importance in determining the role and significance of these particular charges and whether, in fact, the offence or conduct of Mr. McCarthy, as revealed in the tapes, was of such a character, and more particularly linked or properly linked to these charges to warrant the prosecution on the charges in question being discontinued. And in that context, in Glenister too, Moseneke, Deputy Chief Justice, and Cameron J. said, at paragraph 166, that there can be no gainsaying that corruption threatens to fell at the knees virtually everything we hold dear and precious in our hard-won constitutional order. It blatantly undermines the democratic ethos, the institutions of democracy, the rule of law, and the foundational values of our nascent constitutional project. And in paragraph 167, the court went further and emphasized as follows: this deleterious impact of corruption on societies and the pressing need to combat it concretely and effectively is widely recognized in public discourse. And closer to home, as it were, in the Sheikh appeal in the Supreme Court of Appeal, the appeal decision S.V. Sheikh, the court similarly pointed out that the seriousness of the offence of corruption cannot be overemphasized. It offends against the rule of law and the principles of good governance. It lowers the moral tone of a nation and it negatively affects development and promotion of human rights. So against that background, one turns to the reasons for the decision. And the reasons for the decision appear as Annexure JS10 at page 120 of what is referred to as Volume 1B. The court, and we apologize for that, there was a little bit of an unhappy preparation of aspects of the bundle. And in our practice note, we've indicated which volumes of the record have to be or ought to be considered by the court, and those ran from volumes 1 to 32, but the original founding affidavit and annexures was not included, and they were subsequently prepared in 2 volumes, one capital A and one capital B. And so for convenience, when I refer to volumes, I'll refer to volume A, volume B, and that's 1A, 1B, and I'll then refer to the volumes sequentially from one after that. So against that backdrop, one then turns to the statement by Mr. Masher of 6 April 2009, which appears at 120. The point that we submit must be borne in mind is that the NPA in its submissions accepts that the rationality of the decision must be assessed on the basis of the reasons furnished by Mr. Mshe at his press conference at 6 April 2009. And the NPA in its submissions, and this also formulates or guides the submissions that we make, the NPA has said that inasmuch as the answering affidavit of Mr. Hofmeyr traversed a range of additional matters and material going to show possible political interference and conspiracies in other instances, this was done, I quote, only to provide context and background to the decision. And on that basis, which appeared to be common cause between the applicant and the NPA, that the reasons for the decision are to be located in JS10. And I'm not going to take the court through the authorities we referred to in our written submissions, going to when it is permissible to introduce additional reasons not relied upon in the original furnishing of the reasons to justify a decision, and when it's impermissible. The decision of Mr. Masher pivoted on what he referred to as the abuse of process doctrine. And in his submissions, in his reasons, Mr. Masher, page 121 of Volume B, refers to the fact that the NPA had received representations, both oral and written, and that they dealt with the substantive merits, the fair trial defences, that's the second bullet point in the middle of the page, the practical implications and considerations of continued prosecution, and the policy aspects militating against prosecution. With regard to the first three issues, Mr. Masher stated that he couldn't find anything with regard to those grounds that militated against a continuation of the prosecution, and hence they're not dealt with in any detail. He focused, as he stated, on the fourth ground, which he considered to be the most pertinent for the purposes of his decision. And at page 123, in this connection, Mr. Mshe introduced the concept of abuse of process. And he points out at page 123 that there are generally two categories of abuse of process. It may occur either A, because it will not be possible to give the accused a fair trial, or B, where it will offend one's sense of justice, integrity, and propriety. To continue with the trial. And that much appears from the bottom half of page 123. Having referred to the so-called two general categories, which for the most part bear on the question of fair trial, he goes on to say that it's not only where fair trial is implicated, directly implicated, that the abuse of process doctrine or approach falls to be or may be applied. As he says at the foot of the page, fair trial, third line from the bottom, 1, 2, 3, fair trial is not the only test of abuse of process. Abuse of process may occur on its own, either because it will not be possible to give the accused a fair trial, or B, it will offend one's sense of justice, integrity, and propriety to continue with the trial of the accused in a particular case. Discontinuation is not a disciplinary process undertaken to express one's disapproval of abuse of process. It's an expression of one's sense of justice and propriety. And he goes on to quote from a number of decided cases in overseas jurisdictions. He quotes in particular the House of Lords decision in R versus Latif, as well as extracts from the British decisions of R v Martin and a decision reported in 1991, 3 All England reports of R versus Hui Chi Meng. And at 130, if I could ask the court to turn to that page, he concludes, and he says at the top of the page, it's against this broad principle of abuse of process that the conduct of Mr. McCarthy must be seen and tested. The question for close consideration is encapsulated in expressions such as so gravely wrong, gross neglect of the elementary principles of fairness, so unfair and wrong, and misusing and or manipulating the process of court. If the conduct can be so categorized, it would be unconscionable for the trial to continue. And he goes on to say in the 4th paragraph, in the present matter, the conduct consists in the timing of the charging of the accused. In general, there would be nothing wrong in timing the charging of an accused person, provided there's legitimate prosecutorial purpose for it, and the accused is aware, should be aware, or has been made aware of such purpose. It follows, therefore, that any timing of the charge of an accused person which is not aimed at serving a legitimate purpose is improper. And it's against, or in that context, that one concludes that fundamental to the decision of Mr. Moshe was his conclusion that the conduct of Mr. McCarthy offended his sense of what was right. It offended his sense of elementary principles of fairness. It was so unfair and wrong, to quote or to refer to the specific phrases that he used. It was so unfair and wrong that it should be discontinued. The prosecution should be discontinued. The first submission we'd make in this context is that the abuse of process doctrine is not one that's been directly addressed in our case law. But having said that, and if regard is made to the decisions referred to by Mr. Mshwe, the first point to be made is that those decisions involved circumstances under which a court, and for present purpose we don't suggest that a lot turns on it, but nonetheless they were decisions in which a court might order a prosecution to be stopped. And in the Hong Kong Appeal Court decision that we've referred to in our heads of argument at footnote 92, the Hong Kong Appeal Court decision of Lee Ming Ti, which referred to R.V. Latif and pointed out that it was generally accepted that it was only in exceptional circumstances that a stay will be granted where a fair trial is possible. And reference was made to a dictum in the Canadian court that a stay of proceedings is only appropriate in the clearest of cases, where the prejudice to the accused's right to make full answer and defense cannot be remedied, or where irreparable prejudice would be caused, and this is in a situation where fair trial is not implicated, where irreparable prejudice would be caused to the integrity of the judicial system if the prosecution were continued. And in paragraph 184 of Li Ming Ting, the court emphasized that the existence or otherwise of an abusive process is dependent upon the exercise of a judicial discretion, and as pointed out by Lord Steyn in Latif, this judicial discretion involves a weighing of countervailing considerations. It involves a weighing up, on the one hand, of considerations of policy and justice on the other.
Is that, I'm sorry to interrupt, is that in the case where it goes to a court?
Yes.
The court will then
Yes.
weigh that. Yes.
And, of course, to the extent it bears emphasizing, Mr. Moshe was approaching this basis on, or approaching this decision by employing the abuse of process doctrine to guide him, and relying particularly on Latif for the proper approach. And we made the point that for present purposes, we're not going to be emphasizing that this is a decision for a court. Not going to be saying, in this context, this is a decision which Mr. Moshe should never have made, he should left over for a court. We make that submission in a slightly different context. But nonetheless, for present purposes, if, whether by a decision maker in the position of Mr. Mashe, or in the context of that court, a consideration of whether there has been an abuse of process which warrants the discontinuation of a prosecution involves, and we would submit the reasons furnished by Mr. Mashe recognize this, it involves essentially a two-stage test. It involves a determination of whether there has been an abuse, and moving on to the second inquiry, it involves a weighing up whether the nature of the abuse is of such a character, and we would say sufficiently linked to the prosecution in question to justify a stay of that prosecution, and to justify, as it were, the policy considerations in favor of continued prosecution being overridden by considerations of what Lord Steyn referred to as considerations that he encapsulated as being relevant to the question of justice or fairness. For example, in Latif, Mr. Latif had been the victim of an elaborate entrapment process, without which he would never have entered Britain. And it was in the context of that elaborate entrapment process that Mr. Latif entered the country and carried out the crime for which he was charged. And in that matter, Lord Steyn concluded that notwithstanding the court's, or notwithstanding the possible injustice as a result of the entrapment process, the public interest in ensuring the prosecution process continued outweighed that injustice. So, similarly, in another one of the decisions referred to in Mr. Mashe's reasons, R versus Martin, I'm not going to take the court there, it's in our written bundle. Lord Clyde said, and this was quoted by Mr. Mashe, Lord Clyde said, in relation to abuse of process, there must be something so gravely wrong to make it unconscionable that the trial should go forward, such as some fundamental disregard for basic human rights, or some neglect of elementary principles of fairness. Again, we emphasize there is that link between the abuse and the question of fairness, breach of human rights. It doesn't, of course, go to the question of a fair trial itself, but in the context of the entrapment cases, it went to the means which were utilized, used and abused to bring that particular accused before the court. And similarly, a decision such as Bennett, the British decision of Bennett, which perhaps represents the high water mark of the abuse of process doctrine, one is dealing there with a case where the accused was, as a result of a misuse or manipulation of extradition procedures that the court found to be totally irregular. The accused in that case landed up before a British court, and that was a decision, unlike decisions such as Latif and Martin, that was a decision where the court found that that particular abuse, which had led to the accused unfairly and improperly being brought into the country could not be tolerated. And that's a point that we submit as of fundamental importance in considering the nature of the abuse, and particularly the question of a connection between the abuse and the prosecution in question and the concomitant decision to discontinue the prosecution. Insofar as the question of abuse of process as a basis for discontinuing a prosecution may in some form have presented itself in our courts, we've referred to the dictum of Harms J.A. in NDPP versus Zuma.
Before you go to that, in the Bennett decision, what was the decision of the court? In the case of Bennett that you've just referred to.
In the case of Bennett, and that is referred to in the bundle of authority. I don't think that we managed to get those up to the court, unfortunately. Can we hand those up to you, Justices? That's decision 10.
Without going into the details, I just want to know, how did the court decide?
Yes, the court there concluded that the misuse of the extradition processes in question, and the background is usefully just set out in the head note, you needn't go there, it's 137, but that was the case where that abuse of process in those facts was considered to be sufficiently linked to the prosecution and to be of sufficient magnitude to outweigh policy considerations that prosecution should continue.
But that prosecution was linked, the abusive process was part of the case.
Yes. That's the link.
Yes.
That's the point that I'm trying to make.
Yes.
Bennett, there was no suggestion that Bennett wouldn't receive a fair trial. Over there, the means by which he had landed before the court.
They got the facts to get him before.
Yes. And well, that may be contrasted with Latif, of course, where also the means utilized, the entrapment, to bring him into Britain, commit the crime, and hence to be arrested as part of an elaborate sting, were in that context held not to be sufficient to outweigh the public interest in prosecuting the crime. I was referring to the dictum of Harms J.A. in the Zuma case.
President Zuma.
In the President Zuma case.
Yes.
The case is to be found, and at item 4 of our bundle of authorities. I'm not going to take you there. You'll be well acquainted with the dictum in question. I'm just going to read briefly from one paragraph, paragraph 93 of the decision of Harms DP, and the court will be aware that this was the appeal against the decision of Nicholson J. in Natal in the matter that's been referred to as the 179-5 matter, where there was a challenge by President Zuma to the lawfulness of the decision to reinstitute or to prosecute. And in the context of that challenge, which was essentially framed upon the basis that the decision to prosecute that was subject to the challenge effectively amounted to a review or reconsideration of Mr. Nguka's earlier decision not to prosecute, and hence Section 179(5) of the Constitution found application, and it being the contention on behalf of President Zuma that there had been a failure to comply with the requirements of Section 179(5)(d), in particular to take representations from President Zuma. And the court will be aware that in the judgment of Nicholson J. upholding that attack, there was reference to a political conspiracy, political interference, political motives perhaps for the prosecution. And in paragraph 37, in discussing the extent to which Nicholson J. had given credence to and to some extent taken into account in reaching his conclusion to set aside the decision to prosecute, to the extent that he had taken into account political or improper motives at play, Harms DP said the following. He said at paragraph 37, the Nicholson court, dealt at length with the non-contentious principle that the NPA must not be led by political considerations, and that ministerial responsibility of the NPA does not imply a right to interfere with a decision to prosecute. The court then said, well, that needs some contextualization. A prosecution is not wrongful merely because it's brought for an improper purpose. It will only be wrongful if, in addition, reasonable and probable grounds for prosecuting it are absent, something which was not alleged by President Zuma and which he went on to indicate can only be determined in certain circumstances. He did go on to say, Harms DP, that that doesn't mean that in all circumstances the question of ulterior purpose is irrelevant. And he cited an example where the use of powers conferred on a prosecuting authority may be unlawful if used for an ulterior purpose. And he referred to the decision of Highstead Entertainment, where in that matter the police had confiscated certain machines belonging to Highstead for the purpose of charging it with gambling offences. The police were intent on confiscating further machines. Harms DP pointed out that the object was not to use them for exhibits. They already had more than sufficient exhibits, but to put Highstead out of business. And he said in that context, the intended or the confiscation had nothing to do with the prosecution at all. And the power of confiscation in that case was misused or used for a purpose not authorized by the statute. So that was the power of, specifically, it was that confiscation that was set aside. We would submit that it is important to recognize the context in which Harms DP made his remarks. And that context, as I indicated, was one where the political interference was raised in one form or another on behalf of the third respondent, President Zuma, and which did find favor with the court below when upholding the application. And in that context, we say that what is required is that where a prosecution may or might have been influenced or driven by some improper purpose in the form of political interference, there's an additional requirement. Reasonable and proper grounds or probable grounds for prosecution have to be absent. And in our submission, in the context of an abuse of process approach adopted by Mr. Maché on the facts of this case, the NDPP case to which I've referred represents Supreme Court of Appeal authority that a court will not interfere with a decision to prosecute, even if improper purpose, ulterior purpose in the form of some political interference can be shown, unless reasonable and probable grounds for prosecution can be shown to be absent. That, in our submission, is what the NDPP case is authority for. And we make that proposition or submission, particularly in the context in which Harms DP made his remarks. And against that consideration of those authorities, if one can return then to the rationality requirement and the evaluation of the relationship between means and ends, one's dealing, as I've indicated, with the exercise of a power to discontinue a prosecution. The end, presumably, is to address properly the abuse of process which had occurred. And we would start off by making the proposition that that abuse of process in no ways or in no material way affected the third respondent. And to the extent that it did affect the third respondent, particularly insofar as the question of delaying the service of the indictment until...
Sorry to interrupt you before you go to that aspect. The way I understand the papers is that the decision to discontinue was made on the 1st of April already.
Yes.
And so your argument, you are saying that we need to evaluate if that decision was made, proper consideration was taken in respect of the rationality of the decision.
Yes.
Okay. I follow. Continue.
The point I'm making is that one was to deal then with the exercise or intention of the exercise of the power to properly address the abuse of process. The discontinuation, the decision to discontinue the prosecution was taken because of the abuse of process. And the question is, well, if one was exercising the power to discontinue the prosecution for the purpose in some way of addressing and dealing with the abuse of process, it was because of the abuse of process that the discontinuation decision is taken. And it's there that one's looking for a rational link between the two. And the preliminary point that I made before, I'm going to turn now to say, well, let's analyze the abuse of process to see whether there is this link. The preliminary point...
Sorry again. In analyzing that abuse, I would like you to assist us in respect of the contents of the letter in D7.
The letter
It's a letter addressed. It's D7. It's a letter addressed to Haley and Associates, and there's a signature there dated 30/3, and the date is March 2009.
30th of March 2009.
No, it just says March 2009.
Yes.
I think it's D7.
Yes.
When reading through the papers, this letter was a draft. It's a draft letter that was to be sent to Haley and Associates.
Yes.
And that letter deals to a certain extent in detail with the issue of the abuse of process.
Yes.
And at the end, after dealing with that aspect, it seems Mr. Mche and the team, in the last paragraph, they stated, "I must inform you, therefore, that I'm unable to accede to your request to withdraw the charges against your client."
Yes.
I would also like you to address me as to what weight can be put on the contents of this letter, because the decision that is reflected here contradicts the decision that was taken by Mr. Mche about 2 days thereafter or soon thereafter.
And we certainly will deal with that as we turn now to deal with the nature of the abuse.
Okay.
I made the general observation before turning to what was the abuse, to remark that the abuse for all affected purposes in no way affected the third respondent. And to the extent it did, it probably suited him in as much as, and this may be speculative, in as much as he...
Excuse me for a moment. It seems you've got a problem with the machine. Is the machine recording? Pardon? It's freezing. Can we continue, or do you need to get somebody to look at the machine? Fine. Is it okay now? Okay. Thank you. So, sorry for the interruption. You may continue, Mr. O'Connor.
And to the extent that the question of the timing, or particularly the delay in service of the indictment, affected him at all, it very probably suited rather than prejudiced him. And it's in that context, and we'll be coming back to it, that we make the point that insofar as the abuse of process pivots in no small way on some form of injustice, unfairness, even if it's not fair trial implicated, that connection is absent in this case, and we'll return to that. And then the question arises, what is the abuse? It's said to be in political interference in the timing issue, as evidenced in the intercepted conversations between Mr. Guka, former national director, and Mr. McCarthy, the head of the Directorate of Special Operations, the DSO. And we in our heads have divided that analysis up. We've said that, first of all, there is an inquiry into what happened over the period from 1 December 2007 up to 1 November 2007 up to 6 December 2007. The latter being the date upon which Mr. Mche advised Mr. Downer in a telephone conversation on that day that a decision had been taken not to announce the prosecution of President Zuma until after Polokwane. And if one has regard to what was occurring over this process, if one can turn to the chronology that we've prepared, one sees in the decision to prosecute President Zuma that on the 12th of November 2000, well, in fact, it's on the 1st of November 2007. This is shortly before the Supreme Court of Appeal decision in the search and seizure cases was to come out, but clearly in expectation of a favorable outcome, that on the 1st of November 2007, and I'm referring to item 10 in our chronology, if your justices have that in front of you, you will see that Mr. Moshe and his deputies met the prosecuting team to assess the readiness to proceed against President Zuma. And there was a decision, some discussion at that stage as to who should, in law or at least in form, take the decision to prosecute, and that appeared to be principally directed by the view that the NDPP should not take the decision, or formally take the decision to prosecute, because if later representations were to be made in terms of Section 179(5), to give that process proper respect and application, the National Director shouldn't have made that decision. And thereafter, on the 12th of November, there was a further meeting where Mr. Moshe met his deputies, and the question of postponing until after Polokwane didn't arise, and again it was a question of merely who was to take the decision to prosecute. And thereafter, on the 14th of November, item 18, there was a meeting to resolve the question of proceeding with the authorization of the racketeering charges under POCA. And on the 20th of November, item 20, the prosecution team submits an application for the centralization of charges. And on the 21st of November 2007, item 22, Mr. Downer and Mr. McCarthy agreed that the finalization of the indictment was to be left to the prosecuting team. On the 26th of November, Mr. Moshe and his deputies met, and that's item 23, to discuss the prosecution and the need to inform the minister. And on the 27th of November, item 25, Mr. Moshe met his deputies regarding outstanding aspects of the prosecution with a briefing from the prosecution team. and it appears that ultimately this briefing appears to have taken place, and it's common cause that effectively on the 29th of November at item 26, this represents the day in which the prosecution was finally approved. And on the papers, it's common cause that represents the day in which what is now recognized as a corporate decision to prosecute was taken. And the point that bears emphasizing, of course, if one has regard to the overall context of this, and particularly the meetings and steps to which we've been referring, there really was there was no real need for any consideration of whether to prosecute. That decision had been made in the wake of the decision of Squires in Natal in the Sheikh prosecution and the subsequent accumulation of evidence and documentation, and then fortified by the anticipated and then realized decision of the SCA in early November 2007 that material could be utilized. So really, in our submission, it appears that that case against the President had steadily increased in its strength and its potency. And by the time that these meetings took place in November 2007, it was a question of putting in place the steps taken to progress that prosecution. The poker charge, the authorization by Mr. Moshe of the poker charges, the finalization of the indictment, authorization for centralization, and the like. And
in your opening remarks, you did state that the first respondent, they now agree that the decision was a corporate decision.
Yes.
That's not an issue anymore.
Yes.
Yes.
I am referring to this and to this sequence of events to emphasize the point that one would ultimately have to assess the McCarthy conduct insofar as the timing is concerned with the whole question of the prosecution of President Zuma and whether, in fact, it bore any significant relationship to that process which culminated in the decision of 27 November. That's why I've taken the court through that.
I just asked the tax question was also then dealt with in November for the first time.
Yes.
With the poker
Yes,
application.
that's correct.
May I raise one question with you? On page B, 130, it seems that is the reasons.
Yes.
It seems Mr. Nche rests his decision of abuse solely on the question of the timing of the service of the indictment. Am I correct to say that? Or could there be other alleged conduct of McCarthy which, apart from the timing of the service?
Mr. Justice Motley, you're quite correct that page 130, which is B130, Mr. Mshe's reasons, he states in terms that the conduct consists in the timing of the charging of the accused. And it's in that context that the NPA has accepted that in evaluating the rationality of that decision, one must accept that was what the conduct consisted of, and it was that reason as articulated in JS10 that must be evaluated.
I think it's an appropriate time to adjourn for tea, and we'll resume at 11:30. Court adjourns.
Which one is this?
Proceed, Mr. Rosenberg.
The 3rd of December 2007 was dealing with the steps which have taken place in regard to the institution of the charges and service of the indictment. On the 3rd of December 2007, Mr. Mshere reported to Minister Mumanda in terms of Section 33 of the NPA Act. That report appears in D of the record, file D of the record at page 364. And at page 365, paragraph 5 of that report, Mr. Mshere says, we last reported that the only real obstacle to the decision on whether to recharge was the search warrant appeals. As these have now been determined in the SCA, no real obstacle to the decision remains. And in paragraph 6, it remains my view it would be unnecessary and undesirable to wait the outcome of any further appeal to the CC. And at page 367, D367, paragraph 7, Mr. Mshere says, in all the circumstances, I consider it's now appropriate that the decision to charge the suspects on the charges indicated below should be made as it has been. And page D369, paragraph 19 of the report, Mr. Mshere says the prosecution team gave a final briefing to the acting NDPP and the deputy and acting deputy NDPPs during a meeting of 29 November 2007. They confirmed their earlier recommendations concerning the prosecution of the third respondent and the two tint companies, director in the DSO, with effectively the position of a DPP. He formally took the decision. He signed the indictment, as you will be aware, and the memorandum or report to the minister says, in accordance with the above, the investigating directorate, in consultation with the head DSO, me, that's Mr. Mshere, the other deputy and acting deputy NDPPs, and the prosecuting and investigating team, has decided to institute proceedings against the third respondent. And thereafter, if we may return to the chronology that you have in front of you, you will see under item 30 of the chronology, the decision to prosecute the third respondent, that on the 4th of December 2007, Mr. Mshere raised the possibility, or he spoke to Mr. Zuma, and he raised the possibility of postponing the announcement with Mr. Zuma, with Mr. Downer. And a helpful document in Record D is Mr. Downer's recapitulation of the events over this period by reference to his notes and his diary, which one sees at D57. It starts at D56, and he charts and records everything that happened over this period. And on the 4th of December 2007, you will see there at item 15 that Mr. Mshere raised the possibility of postponing the announcement with Mr. Downer, indicating what had still to be done. On the 5th of December, returning to the chronology, one knows that Mr. Mashe spoke to Minister Mabandla. One knows from subsequent documentation in the bundle that Minister Mabandla was concerned with the security and stability implications of serving the indictment on the third respondent prior to Polokwane. And we'd make the point that that's a legitimate concern, and it was a legitimate concern that a number of people had, and it bore no relation to political machinations or political manipulations. And although, for example, Mr. Downer emphasized in his memoranda that it should be solely a prosecutorial decision, and the kind of concern that the minister had, which was not directed towards advantaging any particular party, but was directed towards issues of stability and good order, even to that extent, as Mr. Downer contended, even with the best will in the world, it should be effectively a narrow prosecutorial decision. But we make the point that Minister Mabandla had that concern, and we know that she met with Mr. Mashe on the 5th of December. And on the 6th of December, turning to item 33 of our chronology, and also as reflected at D58, Mr. Downer's recapitulation, we know that Mr. Mashe spoke to Mr. Downer. And Mr. Downer's record of that reads as follows from D58. He, Mr. Mashe, says there's a 90% possibility that he will decide to prosecute in accordance with the draft. Para 16, D58. He says there's a 90% chance that he will decide to prosecute in accordance with the draft indictment. He'll only make the announcement next year. We can file a supplementary affidavit for the CC when this is done. Justice, as you'll recall, that there were those in the NPA who felt, certainly amongst the prosecution team, that it would assist, and for reasons which aren't altogether clear, but it would assist in the application for leave to appeal, which President Zuma was making to the Constitutional Court in relation to the SCA's judgment on the search and seizure. It would assist in the answering affidavit of the NPA if it were able to say that we've proceeded, we've implemented, we've served the indictment, presumably to try and show some kind of reliance and implementation on what had been made available. It's not entirely clear why it was considered important, but for whatever reason, that appeared to be at some stage the prosecution's team's motivation for trying to push through the service of the indictment. And on the 6th of December, returning to D58, as I said, Mr. Mashe indicated that in this connection, a supplementary affidavit for the Constitutional Court application could be filed next year. Mr. Downer records very frank and good-humoured discussion ensues. NDPP mentions that he does not wish to be seen to be interfering in the Polokwane process. He has taken account of President Beki's speech where the President called for calm and stability prior to Polokwane. The NDP consulted with the Minister the previous evening. The decision not to announce the decision to prosecute was his alone and no one else's. Mr. Downer informed Mr. Mashe that in his opinion this was an incorrect decision. Returning to the chronology, on the 7th of December 2007, item 36, Mr. McCarthy, who at that stage, as it appears from certain of the intercepted conversations, was on leave until the 10th of December 2007, Mr. McCarthy spoke to Mr. Downer and indicated that he hadn't been consulted on the decision to delay. The next step in the process is on the 14th of December, where Mr. Mshe signed the poker authorization, and then centralization applications had to be dealt with, and one knows that the indictment itself still had to be finalized. It was ultimately checked by Mr. and approved by Mr. Mgwengwe some time later. Now, perhaps against that background, before turning to the conversations in question, if I could return you back to item 25 on the chronology of the decision to prosecute. On the 27th of November 2007, Mr. Mshe met his deputies regarding outstanding aspects of the Zuma prosecution, and one sees the minutes of that meeting at WH 56376, and it is of some importance. It's in volume 5, and if one turns to 376, one sees that's volume 5, page 376, WH 56. These are Ms. Matska, who is in the office of who was in Mr. Mshe's office, her notes of that meeting, and you'll see at page 376 there's a query from Mr. Dr. Ramaiti, at the 6th bullet point down, will they be ready in February? And if one has regard to the items that were raised, and we've summarized them, all the issues that were having to be considered and having to be completed, it appears that at this stage there must have been real uncertainty as to when, in fact, all of these steps could be done. The poker authorization, the centralization of charges, the other aspects that are referred to here. It certainly would appear that whereas Advocate Breitenbach and Mr. Downer at some stage had met and had considered that the finalization of the indictment was doable by the 11th or the 12th of December, having regard both to the issues raised at this meeting as well as to the unfolding of the further steps thereafter, that it is not at all clear that despite the strategic goal of having the indictment served by the time the Constitutional Court papers were submitted, that could have been achieved. If we turn to the conversations that took place between Mr. McCarthy and Mr. Nguka, they span the period for November, first of all, one can have regard to the conversations over the period for November 2007 to 6 December, being the date upon which the decision to postpone service was taken. And those conversations appear in portion B of the record. I'm not going to take the court to each of those conversations. They're dealt with in our heads. I'm going to give a brief summary of what we believe those conversations over this first critical period indicate. The period up to 6 December 2007, when the decision was taken to postpone service of the indictment till after Polokwane. Now, there were 7 conversations over this period. 2 of those conversations were between Mr. McCarthy and businessman Mr. Mzwi Kumalo. 5 of those conversations were between Mr. McCarthy and Mr. Nguka. The first conversation was on the 7th of November 2007. One sees that in record B, page 3, if you wish to turn there. This was a conversation which related to a Business Day editorial of the 6th of November, and there is where the Business Day editorial speculated apparently as to the strategic pros and cons for the competing parties as to service or not of the indictment on the third respondent before Polokwane. There are some references in that conversation to the man. It speculated that that reference to the man was apparently Mr. Ronnie Casrels, who'd at some stage expressed a view that charging the third respondent before Polokwane would lead to chaos. The second of those 5 conversations, it's at B5, nothing of consequence was discussed in that conversation. The third conversation was on the 9th of November, B7. We've rehearsed each of these in our heads. I'm just going to go through them quite briefly.
So clearly, in respect of these conversations, there's a dispute as to exactly what do they mean between the applicant and the respondent.
Yes.
There's a dispute of fact.
Well, there's a dispute with respect as to interpretation. The conversations are what they are.
Dispute of interpretation,
Yes.
rather. Yes.
Yes. So you can have regard to the conversation. You can read the conversations we have submitted in our heads of argument, and I am summarizing that now, that on any reasonable construction of these conversations, for example, that the second conversation, you can read it, I'm not going to take the court through it, nothing of significance relating to the timing was discussed.
Wouldn't the court be the appropriate forum to sort out this issue of interpretation?
Yes, of course. Of course.
Because we have read the conversation.
Yes. So I'm going to move through that quite quickly. My submission is that the second conversation, and this is in our heads, the second conversation contained nothing of significance. The third conversation of the 9th of November, there's a reference by Mr. Nguka to a possible appeal by President Zuma, but nothing else of any significance. The fourth conversation between these two parties, which you see at B10, Mr. McCarthy indicated he was on vacation at his apartment in Cape Town. There's some general reference to the results of the provincial nominations for the ANC presidency. There's possible reference to Mr. Nguka seeing President Mbeki. What there is in that third or fourth conversation is an indication. At the end of that conversation, Mr. McCarthy stated to Mr. Nguka that he'd taken or followed Mr. Nguka's advice up to Friday, but then he'd received a strong memorandum to say charge and get on with the matter. That appears from that conversation. This description of receiving a strong memorandum or indication from the prosecution team that they were going to charge and get on with the matter accords with Mr. Downer's suggestion to Mr. McCarthy when they spoke, and the approach that Mr. Downer adopted generally, that in fact there should be no delay. We know that in fact on the 12th of November 2007, Mr. McCarthy had spoken to Mr. Downer and had raised the possibility of delaying the prosecution until after the service of the indictment, until after Polokwane, and Mr. Downer had been quite firm in saying that that was not desirable, and that seemingly was the end of the matter. So, as far then as the fourth conversation of the 26th of November 2007 is concerned, that was communicated to Mr. Nguka. Of some significance is that Mr. Nguka, who on the version of the NPA was apparently pulling the strings and giving the instructions, didn't respond at all. He was told by Mr. McCarthy that the prosecution team had taken the view that the matter must just proceed without any delay, and Mr. Nguka didn't respond at all and said, no, well, come on, you can do better than that. The fifth conversation at this period was on the 6th of December 2007. And it was apparent that he was on leave still at this time, and that he wasn't really involving himself in work aspects or work issues. So what can one make of these conversations? Perhaps one can draw the following conclusion. There's some indication that McCarthy may have initially followed the view, or been of the view, that the prosecution could be reinstated immediately. And Mr. Nguka may have been of the view that it would be desirable that at least the reinstitution shouldn't take place after Polokwane. It may be that when Mr. McCarthy approached Mr. Downer on the 11th of November, I think it was 2007, and it may be that, well, certainly when he did approach Mr. Downer on the 11th of November 2007, he was seemed to have been persuaded by the view that by the prosecution team that the criminal proceedings should continue immediately. And again, then, if one has regard to the conversations between Mr. Mshe and Mr. Downer between the 4th and the 6th of December, and has regard to the interaction between Mr. Mshe and the minister over that period, his meeting on the 5th of December, that Mr. Mshe was persuaded and made the decision that the service of the indictment should be held back. And it's not altogether clear to what extent Mr. McCarthy played a significant role in that. So much for the telephone conversations over this period. The telephone conversations, or which took place over the period 7 to 18 December 2007, there were 17 conversations that were transcribed in that period. We've dealt with them on the basis of themes, what broadly they addressed. We've made the point in our heads that the first theme that they dealt with was this question of when the NPA's papers in the Constitutional Court were going to be filed. The NPA were required to file by the 14th of August, the court, December 2007. And what appears from these conversations, at various points, Mr. Nguka sought to encourage the expedited filing of the answering papers in the Constitutional Court proceedings in the hope that these would somehow elicit some negative publicity for the third respondent. To the extent that Mr. McCarthy indicated some willingness to assist, really, if one has regard to what was actually happening, he had no ability to deliver at all or take that matter any further. One knows what was happening on the ground. The second theme is what we've referred to as McCarthy and the arrests at Polokwane. There's some indication in certain of the conversations that McCarthy suggested that in somewhat grandiose fashion that he felt like going to Polokwane and charging the third respondent there. We'd suggest that Mr. McCarthy would have known that he had no power to make good that threat. The third theme in these conversations is in connection with a supposed conversation that Mr. McCarthy had with the editor of the Mail and Guardian, Ms. Hafferty, the intimation being that this could have been at the behest of President Mbeki. In the papers you'll see that Ms. Hafferty robustly denies Mr. McCarthy's account of the conversation. She says it's false and designed to bolster his own sense of self-importance and his sense of from rubbing shoulders with important people. The fourth theme that emerges in the conversations over this period is that relating to an 8-page fax that we know was sent by Mr. McCarthy to Mr. Nguka on the 14th of December 2007. There's no indication from the record what this fax contained.
Yeah, you've dealt with that aspect in detail in your heads. Yes. You can just indicate to us what you think is.
Yes, I'm not going to take that any further. And the remaining themes was McCarthy and Mr. Davids' discussions regarding Mr. Hofmeyer and a possible meeting that was to be held by between Mr. McCarthy, or took place between Mr. McCarthy and Mr. Mbeki after Polokwane, which on the papers and according to Mr. Nguka, who was in his response, took place in relation to Mr. McCarthy's proposed departure to the World Bank. And the final group of conversations are those which are 13 conversations which were transcribed after the results in Polokwane were announced on the 18th of December. And for the most part, they related to expressions of disappointment at the outcome, whether it's Mr. Nguka, Mr. Kumalo, or Mr. McCarthy. They related to the possible extrication by Mr. McCarthy from the NPA, and they related also finally to this meeting between Mr. McCarthy and Mr. Mbeki, which took place on the 21st of December. And the final conversation that requires any attention is the fairly lengthy conversation between Mr. McCarthy and Minister Mabandla on the 29th of December. And the main topic of that conversation, you'll be aware, was Minister Mabandla's proposed response to Mr. Zuma's support, President Zuma's supporters who were claiming a political conspiracy. So, in those circumstances, we make the submission that the nature of the conduct being the political interference in the timing of the service of the indictment was limited and insignificant, essentially. The extent to which there was political manipulation as represented in these intercepted phone calls is not particularly significant. To the extent that it took place, its actual influence on what happened is equally insignificant, or relatively insignificant, in the broader scheme of things. What we see is that at the end of the day, the service of the indictment was ultimately took place on the 28th of December 2007. It's not at all sure when this service would otherwise have, when this indictment would otherwise have been served, whether in fact it was possible and it would otherwise have been served prior to the 16th of December 2007, and it's also unclear the extent to which considerations relating to security and the concerns that Mr. Mshe and the Minister shared regarding service before Polokwane played in that decision. So, that being the case, in the context of a decision to prosecute, which had been developing for years as the prosecution strengthened and its potency increased as, for example, the SCA affirmed the search and seizure process, and as in the course of Mr. Sheikh's criminal trial, further evidence and material was produced. That decision was one which was taken over a period of time, and certainly in November and early December 2007, one was dealing only with the question of when the prosecuting team would be ready to serve that indictment. And if one were to accept that Mr. McCarthy's conduct in any way influenced, and accept it we can for present purposes, on that assumption, if one were to accept that Mr. McCarthy's conduct in any way influenced Mr. Mshe's decision or the decision of the body to delay the service of prosecution, the service of indictment, it really was insignificant in the broader scheme of things. And that is why we made the point earlier, and we'll be dealing with it in more detail at a later section of these submissions. That's why we made the point earlier that the abuse of process cases are essentially dependent on and pivot on this concept of some fairness or injustice or breach of human rights or an accused's entitlement to fairness outside the fair trial procedure. And we said that if one has regard to what happened here, the conduct in no way played any significant role as far as the third respondent's rights to fairness, or his rights generally, were concerned. The decision to discontinue the prosecution is what we must now turn to. And if one goes back to the chronology, one sees that under item 12 on the 10th of February 2009, written representations were received from the third respondent. On the 20th of February 2009, that was followed by oral representations that were made. On the 3rd of March, the prosecuting team prepared a memorandum to Mr. Moshe dealing with those written reps and the oral reps. That appears in the record at volume C, page 1, and it's important to perhaps then contextualize the letter which you referred us to, Mr. Justice Ledwaba, the letter to Mr. Halley, which I said I'd come back to, which it appears at D7. On the 3rd of March 2009, the prosecuting team's memorandum appears at page C1 and following. And at this stage, at page 11 of that bundle, paragraph 10, the prosecution team recommends, this is of course before the transcripts had been presented to Mr. Hofmeyr and Mr. Miznyati. Paragraph 12, we must not discount the value of the forensic successes that it has achieved in this case, despite setbacks that at times have seemed insurmountable. The SCA and the CC have also gone to some trouble to appraise the issues in a sober fashion, and the NPA has emerged with merit. To accede to the representations in a summary manner would abandon all the ground won by the expense of extraordinary effort and resources, and with the approval of the highest courts in our country. A retreat for no good reason at this stage would not be explicable, understandable, or defensible. And it was in that context that the prosecution team prepared and recommended the dispatch of that draft letter to Mr. Halley, setting out why the representations should not be adhered to.
This memo by Downer was done a month before the decision was taken not to prosecute.
Yes. This is after, in relation to the written and oral reps of 10 and 20 February. Returning to our chronology, item 16 of the decision to discontinue, between the 6th and the 16th of March 2009, the third respondent's legal representatives presented Mr. Miznyati, who was at that stage the acting head of the DSO, and Mr. Hofmeyr with certain transcripts of intercepted conversations. On the 18th of March 2009, the NPA management team, and that's item 17, the NPA management team informed the prosecuting team of the nature of the oral representations, and it's agreed by everyone as to the merits of the case. And on the 20th of March 2009, the prosecution team prepared a memo to the NPA management, which one sees at C30. At that stage, at C28 in fact, at that stage, the prosecuting team had taken advice from Advocate Trengrove on the matter, and at C30 it deals with events which had taken place subsequent to that meeting on the 18th of March to which I've referred. And if you were to turn to C30 paragraph 8, it's recorded that Mr. Hofmeyer, together with Advocates Dana Steinberg-Beloy, met with Trengrove SC in Johannesburg on the afternoon of 18 March. Mr. Hofmeyer took Advocate Trengrove through the essence of the oral representations. The team members presented to him some of the considerations for and against acceding to the representations. We all expressed our sense of dismay, our dismay and sense of betrayal. Of course, at that stage, only Mr. Hofmeyer and Mr. Miznyati had listened to the representations. Paragraph 9, Advocate Trengrove advised that in essence the shared decision to prosecute lay at the heart of the fairness of the trial. If this remained defensible in that it was untainted by allegations of political conspiracy and based on evidence that is also so untainted, then the decision to prosecute should remain. And in paragraph 10 it appeared that advice to the same effect was obtained in a consultation between Mr. Dana and Advocate Breitenbach on the evening of the 18th of March, where Advocate Breitenbach advised that if the shared decision was untainted, this provided a basis upon which the trial should. That letter was attached to that memo of the prosecuting team, the letter which appears at D7. Thereafter, between the 20th and the 24th of March 2009, the prosecuting team interviewed Mr. Nguka twice. He wanted to listen to the tapes, but wasn't permitted to. And on the 30th of March, there is a meeting between Mr. Mshe, his deputies, Mr. Mngwengwe, and the prosecuting team regarding the oral representation. The notes of that meeting appear, amongst other places, at Annexure WH1, page 331, which is at volume 4. Those are notes taken by Ms. Matske of that meeting, and there are also some helpful notes to which I will be referring, taken by Mr. Miznyati, which appear in volume C of the record at page 82. And if one has regard to what occurred at that meeting, it was agreed by all the parties that the merits of the case remained strong, that, and perhaps one could most usefully refer to Mr. Mizanyati's notes in volume C of the record at page 82, where after discussing the response from Mr. Nguka, in the middle of the page, it's C82, Mr. Hofmeyr then went through a narration of the tapes that he and Mr. Mizanyati had heard. There's plus minus 100 calls. C82.
In the middle.
Volume C of the record, page 80. Above, Justice Rob, you see the share crowbar just above that.
Okay.
Note Mr. Hofmeyr went through a narration of the tapes that had been heard. There were apparently 100 calls in 6 months. These are ugly tapes and more explicit. According to Mr. Hofmeyr, this showed apparently the mendacity of Mr. Nguka. Mr. Mshere apparently then said, well, or indicated what the way forward was. There was some concern regarding the utilization of the tapes that had been received, and he was unsure as to whether or not these should be followed up with the NIA, page C83, the third paragraph, the fourth bullet point. Mshere says he's not keen in following on the NIA tapes. Attaching a lot of weight on the NIA tapes would be perceived as having gone out of our way to assist JZ. And thereafter, towards the foot of the page, it appears that Mr. Mshere indicated that by next Wednesday, the 1st of the 4th, 2009, we should make a decision. We point out it's not altogether clear why there was this pressure to make that decision by that date. The court will be aware that, in fact, for example, at one stage it was indicated in these conversations that it was important to get the input of both Mr. Nguka and Mr. McCarthy as to the inferences that could be drawn from these tapes, as to suggestions that were made at certain stages, that President Mbeki was also involved and was behind the curtain, to use the phraseology employed by Mr. Mshere in one stage, and so on. And the court will be aware that, in fact, it was only the day, I think it was the day after the decision was made, the 2nd of April 2009, that a request was sent to Mr. McCarthy to answer the list of questions that were presumably considered important and relevant to the exercise of the discretion. Mr. McCarthy had earlier responded to an earlier letter by indicating that he wished to have details of the dates of the conversations, to, I think, to see the tapes and who the parties were concerned. On the face of it, reasonable responses, but it was, in fact, as I say, only a day after the decision that a focused request in the form of 22 questions was sent to Mr. McCarthy. In any event, for whatever reason, Mr. Mashay felt pressure to make a decision, or felt it important to make a decision by Wednesday, the 1st of April. And over the page at C84, one sees it recording, and it does appear from the notes to which we refer, that Mr. Hofmeyr was the one who was arguing forcefully that one couldn't proceed. For the most part, if regard is had to these notes, it would appear that all the other parties broadly appeared to support the view of the prosecution team that the matter ought to and had to proceed. So that was the meeting of the 30th of March. It was on the 31st of March, item 29 of our chronology, that Mr. McCarthy responded, requesting more information regarding the intercepted communications. And on that day, the 31st of March 2009, item 30, it appears that Mr. Mashay, the deputies, and Mr. Ngwengwe met, and the meeting continued in the absence of the prosecuting team. Again, if one refers to Ms. Matska's notes at WH22, page 342, which again is volume 4, one sees that page 342, Mr. Magwenya was included in order to consult with him, and there was some general discussion of the question of ulterior motive jurisprudence and the impact of political manipulation in the light of a watertight case against Mr. Zuma, and it was agreed at that stage that although Mr. Mshay had seemingly been disinclined to listen to the tapes, he was going to listen to the tapes that evening. And listen to the tapes he did that evening, and on the 1st of April, he announced to the NPA management team his decision to withdraw the prosecution. And that meeting, it's an important meeting, obviously. One sees that, the minutes of that, or notes of that meeting, rather, taken by Ms. Matska at WH25, page 345, volume 4. And also, if I could ask you to turn at the same time to Mr. Miznyati's notes of that, which are in B of the record 75. Notes for me. And perhaps we could start with Mr. Miznyati's notes at B75. In the middle of the page, Mr. Mashay, or perhaps if I could start at the top. Mr. Mashay said he'd received a response from Mr. McCarthy. He needs inter alia all the necessary and relevant facts in relation to the recordings, and he sets that out, and it's then recorded that the NPA had sent Mr. McCarthy the 25 questions. We know that they hadn't sent them at that stage, but they were obviously preparing to send them at that stage. We then went to visit the NIA last night. That would have been Mr. Mashay and his deputies. And Mr. Mashay says, after listening to the tapes, and I'm reading from the middle of the page of those notes, after listening to the tapes, he can't separate Leonard's involvement. He got angry. He can't go on with this case. He's decided to drop the charges. We just need to prepare the motivation, and how do we substantiate this decision? He says we have sufficient information to explain our decision. He goes on to say he has no doubt that the President may have been a player behind the curtains. He then goes on to the inferences that he draws about the involvement of the President. That refers to one of those conversations where Mr. Nguka had indicated to Mr. McCarthy post-Polokwane, you're on your own. And the comments of various deputies are there reflected. The third bullet point from the foot of that page reflects Dr. Ramaiti saying that there must be a valid and sound basis, which he's not sure we have. This needs a little bit more research, a lot of research. And then over the page at B76, it's proposed that we only use the Hully tapes and not the NI tapes. That's of no real relevance. Mr. Mashay sort of agrees with me. And where's the Matska? The Matska tape. Thank you, Justice Ludwaba. If one turns to Ms. Matska's notes of that meeting at WH25, page 345, volume 4, she too records the response that had been received from Mr. McCarthy indicating what he required in order to respond more fully, and the option that's suggested by Mr. Hoffman is to provide a set of questions to him. And then at the top of page 346, Dr. Ramaiti says, or appears to have said, our approach is based on the manipulation. Are we suggesting that in the so-called manipulation is Mr. Nguka and Mr. McCarthy involved and no others? And the suggestion is, well, if we're going to draw an inference that this conspiracy or manipulation goes more widely, well, don't we have to request responses from the people involved, not only the presidents? We need to provide a very clear background. Yes. Mr. Mashay seemed to vacillate in his approach. We've seen earlier in the notes of Mr. Mzanyati his suspicion that the President Mbeki, was behind the curtain. He then says, well, here at a later stage of this meeting, well, nowhere in the tapes we can't say anything with regard to the President. Mr. McCarthy and Mr. Nguka are the main players. And it's then said that by Mr. Mizanyati that this raises a very important issues. And if you are talking about manipulation, there must be some kind of clarity about who the manipulating parties are. And does it, in fact, mean that President, as he says here, President Mbeki and Minister Mabandla are implicated? And then at the foot of the page, Mr. Moshe then says, well, I have no doubt that it might be a case of President Mbeki working behind the curtains. Over the page, at page 347, Dr. Ramaite, who kept sounding words of caution, said, we're trying to get the full story at face value. Mr. McCarthy abused the process. How and what way did he abuse the process? And if so, did he and Mr. Nguka act on a frolic of their own, as he put it? Mr. Moshe at that point seemed to indicate, well, we should forward the questions to Mr. McCarthy with a timeline. There's discussion of the tapes then. So that, and then if one can move forward to page 352, in an echo of what one sees recorded in Mr. Mizanyati's note, Mr. Moshe indicated that he listened to the tapes. I've come to the conclusion that whilst we were honestly working on this matter, I can't go on with the matter. Seriously decided to drop the charges. We need to work on the motivation. We need to look at the release and substantiate it. We have sufficient to say the process was influenced. I want to exclude the minister. I have no doubt he was moving behind the curtains. If one traces back that metaphor, that would appear to be the president. And then there is discussion of, well, if that is Mr. Moshe's decision, in principle, we get a the sixth last line, Mr. Mizanyati again emphasizes that the packaging of the reasons will be crucial. And Mr. Ramaiti repeats, you're going to need a firm and sound legal basis. You're more worried about the legal arenas and need a sound and firm legal basis. So that is what we have on the minutes of, or what occurred on the meeting of the 1st of April 2009. And we submit that what appears from this is that the decision of Mr. Moshe was an impulsive decision. It wasn't at that stage a reasoned decision. We would submit it wasn't at that stage a rational decision, backed by any reasons. It was a decision which reflected his own sense of betrayal and anger and outrage over the McCarthy conduct. We would submit that as at 1 April 2009, unreasoned and impulsive as it was not a rational decision. The reasons were worked out and developed. or articulated and appeared in JS10, the press announcement of 1 April 2009. 6 April 2009.
In essence, your submission is that a decision was taken and thereafter reasons were put together.
Well,
Do you understand well?
well, a decision was taken. In a sense, the reasons that were provided on the 6th of April represented Mr. Mache's reasons. They hadn't been formulated or considered in any particular way on the 1st of April, other than we would submit that there was the sense of outrage and betrayal, and we say that the decision in those circumstances, made prior to consulting or getting further information from possibly involved parties such as Mr. McCarthy, it was taken prematurely, it was taken impulsively, and if one then has regard to the reasons as developed, and they may be accepted to be the reasons lying behind that decision when an attempt was made to articulate the reasons for what had taken place. Those reasons, in fact, buttress the submission that we've made. We've indicated that if one turns back to Annexure JS10, what one sees there is an emphasis on Mr. Mache's personal sense of outrage at what had occurred. He concluded that this amounted to an abuse of process. His reasoning in JS10 appeared to be that because of the sense of disquiet and the sense of disapproval that this conduct evoked in him and in any right-thinking person, presumably, it constituted or qualified as abuse of process. In the first instance, we say that that is not sufficient for the purpose of applying the doctrine, or that concept of abuse of process. Returning to Latif, what was required of Mr. Mache was not merely to conclude that this conduct provoked a sense of outrage in him. What he had to turn his mind to was the second question, which he never did. And the second question is, did this abuse, or was this abuse of such a character that in weighing up policy versus justice, one had to conclude that this was such an egregious contravention of the rule of law or President Zuma's rights or fairness generally, that it warranted the discontinuation of the prosecution. We have indicated in our submissions that in the papers in this matter that the decision was fundamentally irrational. And why we say it was fundamentally irrational was, in the first instance, we say that in weighing up or in evaluating the abuse question, the decision maker had no regard, or insufficient regard. We would in fact say had no regard.
Now, on the, I still need to press on this one. The record reflects that they met on the 30th, not
Yes.
so, to listen to the tape.
No,
I'm talking from their point. I'm not, just let's cut the other things.
They met on the 31st, and
On
they
the
listened
31st, to listen to the tape.
and they listened to the tapes that
That was the
evening.
day before he took the decision.
Yes.
Now, after listening to the tape, was there a discussion about their views concerning what they've just heard?
No, well,
Is there any record
there's
of
no
that?
record of that.
And they did not take a decision on the 31st.
Well, what we have is that the notes of the meeting of 1 April reflect clearly Mr. Mashe indicating, I have taken a decision after listening to the tapes last night.
Was there any discussion of what they've heard in the tape? I take it the people who were at the meeting of the 31st listening to the tape were more or less the same people on the 1st, not so? Was there any occasion before he made the announcement or after he made the announcement where the views of other members were heard about the impressions on the content of the tape?
As we understand what is put up in the answering papers as buttressed by notes and minutes of meetings, there's no indication of Mr. Mashe and his deputies caucusing and discussing and coming to a joint decision on that score. We have merely the record of the discussions on the 31st, no decision, and we have the record of what happened on the 1st, and there's clearly an indication of an announcement by Mr. Mashe to his deputies and everybody else that I have decided I can't go on. And the response there appears to be, yes, I've been referred to page 249 of the answering of the answering affidavit of Mr. Hofmeyr at page 200 and paragraph 268 to deal further with this point raised by Mr. Justice Mochley in paragraph 268. Page 249, volume 3. At page 200, paragraph 266, Mr. Hofmeyr says, until the evening of 31 March 2009, only Ms. Nyati and I had listened to the recordings. Once the NIA confirmed that we could make transcripts of the recordings, Mashe decided it was time for him and the deputies to listen to them too. This happened on the evening of 31 March 2008. On the following day, 1 April 2009, Mashe met with the deputies and with Mr. Mngwengwe. It is evident from the record of that meeting that he was disturbed by what he had heard on the tapes. Now, Mr. Hofmeyr would have been present there as well. And it's evident from the record of that meeting that he was disturbed by what he'd heard on the tapes until the night before, when he'd listened to the recordings before, he'd relied upon reports from Ms. Nyati and me to tell him what the recordings contained. He told, paragraph 268, he told us that listening to the records had made him angry. He informed us that he could not go on with the case and that he had decided to drop the charges, in other words, to discontinue the prosecution. Yes.
Mr. Rosenberg, but if you read that, it's clear that he says there it was my decision to discontinue.
Yes.
Is that correct?
Yes.
Because that's how I understand it. I'm not
Unambiguous.
Yes.
Do we have an affidavit from Mr. Mche specifically dealing with this aspect as to how the decision was taken,
We have an affidavit from Mr.
other than the confirmatory affidavit?
confirmation confirming this account.
But there's no confirmatory affidavit from the other NDP parties. Yes.
But for present purposes, the answering affidavit is clear and appears to speak fully in line with the documentation. 269, Mr. Masher felt betrayed by Mr. McCarthy. Once he heard the recordings, he realized to the extent to which Mr. McCarthy had manipulated people, he felt. So, the sense of betrayal and outrage articulated and felt by Mr. Masher led him to the conclusion that this was an abuse of process of a kind which warranted the discontinuation of the prosecution. We say that that decision was irrational for certain reasons. In the first instance, we've submitted it was irrational because, in fact, he failed to take into account or pay any consideration to the factors which indicate, or the policy considerations in support of a continuation of a corruption prosecution of this magnitude and kind in particular, which had as long and difficult and significant provenance as this prosecution had. And in that regard, we say that he failed to have any proper regard, if one formulates it in a slightly different way, but with relation to this exactly the same issue, he failed to have any regard to the second question in Latif, the balancing up between the policy consideration of continuing a prosecution like this as against considerations particularly of fairness and justice to the accused. And we say that considerations of fairness and justice to the accused really hardly entered into it, or certainly didn't enter into it to any material degree, regard being had to the nature of the conduct and the limited role that that conduct played in the process as a whole. If you compare that to the kind of abuse of process which had moved the court in Bennett to discontinue, but in fact, you compare it to the kind of abuse of process which, notwithstanding the egregious nature of the conduct and the extent to which it was criticized by the court in Latif, the entrapment and so on, had been held in cases like Martin or Bennett not to warrant the discontinuation of the proceedings.
Do the papers anywhere reflect any material prejudice if the case would proceed to the third respondent?
With respect, no. Justice Ledwaba, you will be aware, for example, that in Mr. Masher's reasons at JS 10, he made it clear that the representations from President Zuma had concentrated or referred to four aspects. The merits, the fair trial defences, the practical implications and considerations of the continued prosecution, and the policy aspects militating against prosecution. There's no implication that the fair trial defences were implicated in any way. To perhaps answer the question which you may be posing, Mr. Justice Ledwaba, in relation to any other unfairness in the sense of Latif or in the sense of Martin outside the fair trial, no. with respect, there's no indication of any unfairness at all or prejudice that may have been sustained by what, in the nature of things, was ultimately a relatively short delay in service of the indictment. I've made that point already, having regard to the time frames concerned. And in those circumstances, if anything, we've made the point, certainly in relation to holding the service over till after Polokwane, it probably suited the third respondent rather than prejudiced him.
As a follow-up to your question by my brother here, was there anything or is there anything on the papers which indicate that the conduct of Mrs. McCarthy and Mrs. Nuka tainted the evidence uncovered by KPMG in any way?
No. Nobody suggests that. Nobody suggests that, other than the timing, that the case against the third respondent was implicated, affected, or contaminated in any way. Those are our submissions on the question of rationality. I've got a handful of more abbreviated submissions I wish to make. If I could make them after lunch, I want to see if I can cut short the submissions in the light of the indications from the NPA as to the concessions or the approach that they may take. The submissions I was going to make may in fact be significantly shortened.
I think then this would be the appropriate time to adjourn. The court will adjourn and will resume at 2 o'clock.
Joel, will you tell Peter we're doing a crossing to Cape Town? You must just give him your camera. You have a third person now helping you. Milo is doing something for Forza because they ran out of tools, or Zulu because they ran out of the tools, so Teresa's helping.
Okay.
You give her 4 of the...
Yeah, I've basically got everything I want. I'm going to write you a rough script and then...
They said they've got about 2 minutes, so it's going to be a very short. Let's just test sound.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Walid, we're ready for you guys. Okay, 5 minutes. Cool, no worries. Cool. About 5 minutes.
Yeah, on this I do. Can I just use it to... Oh. Is there any stuff I can plug into here?
I've got one back camera as well, but look at you, clever girl.
You know, we don't play here. There's no playing. Where can I put this?
You want to? Okay, we're gonna keep it there at the back.
And then there's...
Actually, we want to charge it now, so let's keep it. Oh, not really. While you're spotting, I'll take some money as well. So much business news going on today. The GDP did better than expected.
Yeah.
Barclays pulling out.
Yes.
And there's some there's other big things. Can't remember. Eskom's getting a tariff increase.
Yeah, I know.
And then it's motion of no confidence this afternoon. Motion of no confidence.
Can you imagine if it works?
I don't imagine it will, but if it does, we are in for a long day.
What time
Then
is
we'll
that?
go. Can you stand up and go, Your Honor, please just follow on. I just need James Staff quickly to do a few things.
Yeah, I'm sure that will go down like very well.
Don't drop your phone.
About 1:30 and about the dice card, you know.
Level. Ayuthi. Yaphetha. Awuyirate. Awasayirate. Etlanyana kubhekenda. Yeah, ngize manje. Yeah, that's my next number, but I'm just scared the petrol is very low here. Yeah. The audio is not clean. Turn up. This microphone, the audio is not clean. How are you? Yeah, but anyway, let's try to simplify.
No, they take
Yeah, okay. No, hold on to it.
Why?
Oh, okay. Guys, but the audio. Okay, comrade, can you drop this call? I want you to call me on in a few seconds. I want to divert my number to the other phone. This one is losing battery. Yeah,
okay, kid.
This phone is losing battery. It's dying. Can you please just drop it to the phone? I'll divert you to my other number, my other phone.
Ah, there were 2 guests. Sorry.
No, they're still going to cross to us. Because who told them that?
That's whoever says I'm not the more it's going to.
Yeah, it's okay. Don't do it tonight.
Don't twist it. Just be careful not to drop it on your live. Because it's going to be gone.
I can hear you. I've got a very dodgy mic though. I can hear you.
Yeah, well.
One, two, 1, 2, 1, 2. Hector, how's that? Hector, are you happy with that? Hello?
Oh, shit. Let's open this phone.
Hello?
Television every day has its own challenges. Yeah. But Michael, I think no, but by half past that one, let's test everything. Yeah. That's not going to work. When how can you mustn't wait for us. You must be ready and boom. But now it goes on now. It means
Hector? Hector? Hello?
What you're calling so bad. These are the things I try to avoid. Too long that can require one. One more. So, my bro, I just wanted to verify. We are at the High Court there. So, okay, fine. We're going to call back now. Stand by. Okay. Please stand by, guys.
sorted. One, two, testing, 1, 2. Testing, 1, 2, 1, 2, testing, 1, 2.
So while President Baker and Zuma's lawyers are saying that the timing was so opportune that this was some sort of revenge for having lost the 2007 National Elective Conference in Polokwane, the DA has come out saying that, well, in actual fact, if we look at
1, 2, testing sound, 1, 2. 1, 2, testing sound, 1, 2.
was made after the Polokwane conference, which actually, if you think about it, in the grand scheme of things, works to his benefit as that reputation damage wasn't done and it could have affected choices winning at that national, that 2007 December national election conference. So they're turning their arguments on its head, and this is what they do. We just got into lunch now, and the biggest question that's been put before the court is the question that this revenge had gone ahead, the Democratic Alliance believed that it was not up to Mokotedi and to drop those charges in 2009, as the state believed they had a very strong case, and it was out of an emotive and out of a position of anger that he made that call, and then only later came and justified the reason for dropping it. But we've just gone into a lunch break. We're going to come back with
How did it go? To the best of your ability.
Yeah, bro, that's about it.
What you must just do, what you understood.
Because they'll never come together. Otherwise, they don't have lunch now.
Mike, I must be on. Sorry? No, you can switch off. You can switch off. Later, man. Maybe later, yeah. Happy with that, eh? This shit's killing me. Say hi, Mom.
only thing. That's the only thing. Over.